Hi, this is Aaron Lacey. Good morning if you're in the West, and good afternoon if you're in the East. You're tuning into the proposed elimination of arbitration clauses, which is part of our Unraveling the Proposed Borrower Defense Rule series that we've been doing. This is the third in our four-part webinar series. We'll have one more next week. Please remember, if you're listening to this webinar at some time after the original air date, so if right now you are listening to a recording, it is possible that law and guidance has changed. And in fact, as I mentioned in the previous webinars in this series, this whole series is about a set of proposed rules. So we expect that that there will be final rules ultimately that will come out, and so that the law will look a little different. So just please keep that in mind if you're listening to this on recording. So with that having been said, one of the things I want to point out today right off the top, I'm delighted to be joined by one of my colleagues, another partner here at Thompson Coburn, Mr. Jeff R. Fink, or Jeff Fink. And Jeff, I'll turn it over to you to talk a little bit about yourself.
Well, good morning, good afternoon. Hi, this is Jeff Fink. I am a partner at Thompson Coburn, been practicing here for over 22 years, and in the post-secondary institution world, I have been defending lawsuits and arbitrations. Many of these have been brought by students in many states throughout the country. I've also been involved in state attorneys general lawsuits against schools. And typically, these are involving claims of fraud, misrepresentation, perhaps violation of state consumer protection laws, False Claims Act, a lot of different topics, things that students and attorneys general have gone after, been representations about employment opportunities, alleged promises about jobs and salaries, transferability of credits from one school to another, financial aid, accreditation issues, and just the overall quality of education. Also worked on overturning government suspensions on financial aid programs, including veterans benefits, and also defended employee-related litigation. Aaron, I'll turn it back to you.
Thank you, Jeff. So those of you who've listened into these before have heard me go over my bio. I'm a partner in our higher education practice here, and will work with and support Jeff often in his efforts on the litigation side. My practice is more regulatory in nature. I've typically divided into sort of three buckets: provide regulatory counsel to schools on federal, state accrediting agency laws and standards. So things like bar defense, financial responsibility, and the whole pantheon of Title IV regulations and requirements. We also assist with post-secondary transactions, contract drafting, negotiation, policy creation. We'll help folks create and design compliance systems, so that's policies and forms and all those kinds of things, consumer information. And then, again, as Jeff mentioned, we represent institutions in student employee litigation, and I also represent institutions in administrative proceedings. So if you are dealing with the Department of Education or an accreditor or a state agency and you are not in court but at the administrative level, so say you're appealing a program review or something like that, that's the kind of work we'll do. So here's our webinar series schedule. You can see we've already been through the first two. The one we're on today is the proposed elimination of arbitration clauses, and next week we'll talk about the repayment rate that's been proposed for proprietary schools. The presentation outline today, we're going to start, as always, talking just a little bit about the current rulemaking and the timeline, and then I'll walk through the proposed class action and arbitration provisions, sort of the framework that the department has proposed, and I'll speak just briefly to the department's policy bases, and then Jeff is going to jump in and talk about sort of an alternative view on arbitration and the value of arbitration, and then talk quite a bit about points of significant concern with these proposed regulations. Finally, Jeff's also going to spend just a little bit of time talking about what you ought to be doing while these rules are pending and between now and the time that whatever ultimately becomes effective. So try to give you some practical advice on how to deal, if you have arbitration clauses or class action waiver provisions, how to manage those in the interim. And then, as always, at the end, we've got some links to some resources for you. Okay. So the rulemaking timeline, you all know this all started with the negotiated rulemaking that occurred during January, February, and March of this year. So the department brought together a bunch of stakeholders, folks from the industry and who were interested in the industry, and they talked about what these rules potentially should look like. There was not consensus at the end, meaning at the end of the three meetings, everyone didn't agree on what the rules should say. So the department has a fair amount of flexibility in that scenario to come up with and propose what they think the rules ought to look like, which they did on June 16th, and that's what we're talking about today is those proposed rules. The public was invited to comment on those proposed rules, and the deadline for comments was August 1st. You can go out and see those comments right now. They are at regulations.gov, and there were just south of about 11,000. Many of those look a lot alike, or they're from private parties or individuals, and may just be a page or two. But there are also some very sophisticated multi-page comments from different institutions and associations, so a lot there to look at and think about. November 1st is the deadline for the publication of the final rule, and what we mean by deadline is if the department wants a final version of these rules to be effective by July 1 of next year, they have to get the rule in final form published and through OMB and into the Federal Register by November 1st of this year, and we very much expect that they will do that because they want to hit that July 1 deadline. Assuming they do, then the effective date of the final version of these rules would be July 1 of next year. One of the things we try to sort of highlight with this slide that's been in all our presentations in this series is that this proposed rule package touches on a lot of different areas. It is generally referred to in the press and elsewhere as the bar defense rule or rulemaking, but there are a lot of other things that relate to the bar defense rulemaking or were just ultimately became part of this package. Arbitration agreements, which we're talking about today, are provisions that provide for arbitration. We're very much a part of that. In fact, they were originally not on the table when the negotiated rulemaking began, but they were brought up during the process, and the department decided to roll a consideration of arbitration and class action type provisions into the rulemaking package, and it eventually made its way into the proposed rule. So, take a deep breath. With that having been said, what is it exactly that the department is proposing, and how are they going about doing that? The first thing I want to point out, sort of from the standpoint of regulatory mechanics, is what the department is doing is they are proposing that these new requirements become terms or part of your participation agreement. Right, every institution has a program participation agreement with the Department of Education that sort of sets out the terms of the participation in the federal financial aid programs. So the HEA actually directs the department to enter into agreements with institutions specifically to participate in the direct loan program. And then section 685-300 of the regs, so the first part, right, that's the statute, and then the regulations that the department has promulgated pursuant to that statute requires institutions wishing to participate in the program to, again, enter into a written program participation agreement with the department. By the way, on our slides here at the bottom left-hand corner, if you're interested in looking these laws up, we're trying to include citations where appropriate. So the direct loan program agreement that's referred to, and we talked about on that prior slide in the HEA and then at 685-300, is part of each institution's program participation agreement, right? And I highlight that because your program participation agreement that you actually sign when you go through recertification is sort of an umbrella document, and it includes agreements that relate to the different types of programs or terms that relate to the different programs in which you participate. So you've got this blanket program participation agreement, and the terms of your direct loan program participation are wrapped in. And I've set out here, if you actually look at the first page and second page of your program participation agreement, you'll see there's a section titled Scope of Coverage. And underneath it, it says, and I've excerpted a language here, this agreement covers the institution's eligibility to participate in each of the following listed programs. And one of the line items is going to be the Federal Direct Student Loan Program. So this is how the department is sort of introducing these ideas with regard to arbitration, is they're making them terms of your participation agreement. In other words, if you want to participate in a direct loan program, you got to sign the program participation agreement, and they're going to include these concepts relating to class action waivers and pre-dispute arbitration as terms of your program participation agreement. All right. The justification for doing this is in the HEA, the department is directed to include in the program participation agreement, among other things, such other provisions as the Secretary determines are necessary to protect the interests of the United States and to promote the purposes of this part. So that's the idea, is the department is saying, look, you know, we and you have to enter into a program participation agreement pursuant to the law if you want to participate in the direct loan programs, and we are authorized and in fact directed by Congress to ensure that this agreement includes certain terms. One of the, categorically speaking, sets of terms that we're supposed to include are terms that are designed to protect the interests of the United States. And it is our view that these provisions relating to class actions and pre-dispute arbitration are necessary to protect the interests of the United States. So that's sort of the foot in the door for the department and the justification and mechanism for introducing these provisions. So what exactly do they propose to do? They want to insert these new requirements into 685-300. I mentioned earlier that's the section of the regulations that include all the specific terms that have to be included in the direct loan agreement, participation agreement between institutions and the department. And again, the department contends these new requirements are needed to protect the interests of the United States. They would become a condition of participation and not only be in the reg, but would appear in the school's PPA as well. It's really important to understand, and we're going to highlight this distinction in a couple of other points in the presentation, but the new requirements relating, again, to class action waivers and pre-dispute arbitration would only relate to student claims or complaints that could form the basis of a borrower defense claim. Now, that's a lot of what's going to fall into the category of student claims or complaints. But it's not everything. We talked about in the first webinar in this series, and the department articulates in the preamble, some examples of claims that would not form the basis of a borrower defense claim. And the examples they give are, you know, a slip and fall, right, on your campus, so a tort-style claim. They also talk about claims that involve allegations of sexual harassment or violence. And they say, you know, those are certainly important, but they could be brought under different areas of the law, and there are other ways that victims would have to try to exercise their rights. In this case, when we're talking about these new class action arbitration claims, they have to be claims or complaints that could form the basis of a borrower defense claim. Now, what does that mean? I've told you what it doesn't mean. It doesn't mean torts. It doesn't mean the sexual violence or type claims. But it means any claim or complaint that's based on an act or omission of the school that relates to the making of a federal loan or the provision of educational services for which the loan was provided, and could be asserted, doesn't mean it has to have been, but could be asserted as a defense to repayment under 685-206C and 685-222. So let me sort of make this a little simpler, right? I mean, it basically means if someone is making a claim or filing a complaint, and it relates to something your school did or forgot to do, and relates to your provision of educational services, which is very broad, right? That's almost everything you do. And also either constitutes a breach of contract, some sort of misrepresentation or substantial misrepresentation, or was the basis of a judgment in a court or under some other tribunal, right? So those are the things that form the basis of a borrower defense claim. And then again, those are the proposed regulations that the department cites here. For purposes of this presentation, to keep this simple, we're just going to refer to all of this as a qualifying claim, right? So we're talking about a student claim or complaint that would satisfy these requirements. We're just going to call that a qualifying claim. So what is the department proposing with respect to these qualifying claims? First of all, and these are the 6 sections or buckets of in this case that I'm dividing this into. The first is internal remedies, and we're going to break each of these down. I'm going to walk through them, but here I just want you to let it sort of wash over you so you can get the high-level understanding of what's in this proposal. There's a general prohibition on schools compelling students to go through internal processes. You have to let them go straight to the court or elsewhere if they want to. There are provisions prohibiting schools from obtaining or enforcing waivers of class action lawsuits that relate to qualifying claims. There's mandatory language relating to class actions that institutions would have to include in certain types of agreements. pre-dispute arbitration agreements. So there are provisions prohibiting schools from obtaining or enforcing certain types of pre-dispute arbitration arrangements. There's mandatory language, again, relating to pre-dispute arbitration. And the department, let me just note here, you'll see the second box, class action waivers, right, is followed by mandatory language relating to class actions. The department is sort of giving institutions an option here, and we'll get into this in more depth in a minute, but just structurally so you understand, what they're telling institutions is, look, if you've got a class action waiver, right, you either have to take it out of the agreement or you're going to have to include this mandatory language along with it in that agreement that we've come up with. Right, so you can come into compliance essentially, assuming these rules were to become finalized, by going one or two routes. You either take it out entirely or you couple your language with the mandatory language that they've proposed in the law. Similarly, with pre-dispute arbitration agreements, you can leave it in, but if you do that, you have to include their mandatory language, or you can just take out your pre-dispute arbitration language altogether. And then finally, the department has a new notification requirement that we'll get to, and they want you to report to them if these types of qualifying claims are being filed or submitted either by you or by the student, which is an important point. All right, so let's break these down in a little more detail. Exhaustion of internal remedies, what does that mean? Institutions would be prohibited from requiring students to first seek resolution of qualifying claims through an internal process. So in other words, if somebody files a complaint or a claim, and it's a qualifying claim, so it meets those various criteria we talked about 3 slides back, then you have to let the student go directly to an institution's accreditor or to an appropriate government agency if they want to. You can't have a policy that says you have to go through us first before you go to the accreditor or the agency, et cetera. And a lot of schools, frankly, already permit that. I mean, I know when I work with schools and we design grievance processes, typically we'll just indicate in the grievance process, look, we encourage you to come to us first because we would like to resolve this as easily and amicably as possible, but you are welcome to go ahead and call, and then we'll include the information for the accreditor or the state agency. And many state authorizing entities actually require that you include something like that along with your grievance procedure. So I don't know that this particular requirement is a significant imposition for every institution out there. I think a lot of schools already, they encourage an internal process, but I don't know how many actually have a policy that requires that the student exhaust the internal process before they contact an accreditor or a state authorizing entity. Also, it'd be really hard to enforce that as a practical matter. So the second piece is the class action prohibition. Schools would be prohibited from relying on a class action waiver in a pre-dispute agreement. So relying on, the department in the proposed reg gives 6 or 7 different examples of what they mean by that, and Jeff can talk to that later. He has a better sense when you're talking about the different types of motions or things you might try to do in the context of litigation. But keeping it simple here for a minute, basically what the department is saying is, look, you know, you can't call out that provision. If you've got a class action waiver, basically you can't use it or try to enforce that in any way. If the agreement is, and this is important, if the agreement is with a student and with respect to any aspect of a class action that relates to a qualifying claim. Couple of important points to make here then. I mean, first of all, we're only talking about agreements, we're talking about class action waivers in agreements with students. So here we're not talking about any type of agreement you might have with an employee. Right, that's not what this proposed regulation applies to. Secondly, and it has to be with respect to any aspect of a class action that relates to a qualifying claim. So again, theoretically, if you had a class action and the only claim involved in the class action had to do with, 100 people who had all slipped on the same icy pavement, that would not be implicated by this proposed rule. That would be outside of this proposed rule because it doesn't involve a qualifying claim. The other thing I want to point out is the rule does not specify that the class action waiver has to appear in an enrollment agreement or, for that matter, in an arbitration agreement, right? It just says schools would be prohibited from relying on a class action waiver in a pre-dispute agreement, right? Any pre-dispute agreement, whether it refers to arbitration or not, and it doesn't necessarily have to involve enrollment in this context. So it is conceivable to me, there are portions of this proposed rulemaking package, like the repayment rate that we'll discuss next week, that are specific to for-profit institutions. But the vast majority, at least in theory, applies to private, nonprofit, and public institutions as well. While in this case, as a practical matter, in our experience, we expect most institutions with enrollment agreements are proprietary institutions or technical or career schools, there is nothing in the rule that specifically restricts its application to proprietary institutions. All of this is to say, if you are a private, nonprofit institution or a public school, and for some reason you have an agreement with students, a pre-dispute agreement, and it could be in any context. It doesn't have to be an enrollment agreement, right? For use of athletic facilities, something along those lines, there could be application here. My guess is the department would probably say, well, that's not what we were really thinking about. But the fact is there's nothing in the law in the way it's written that would exclude those agreements from coverage. And maybe in the final rule, there will be some clarity on that point. The mandatory class action language. So I mentioned to you what the department is basically saying is, you know, and let me just go back to this slide. For class action waivers going forward, if you've got a pre-dispute agreement, right, with a student, and we're talking about class actions that rely to qualifying claims, you can't rely on that class action waiver. Now note, the department doesn't say you can't put the provision in an agreement. It just says if it's there, you can't rely on it, right? And the department takes the view that, you know, you ought to either take it out, or if you don't, then, and you leave it in, not only can you not rely on it, but then you also need to include some specific language, and they propose this language. And it essentially negates the provision to some extent. So going forward, under the proposed rule, if you have an agreement, that a pre-dispute agreement that includes a class action type waiver, right, what the department says is that agreement has to include this required language. It should say, I'm just going to read it. We agree that neither we nor anyone else will use this agreement to stop you from being part of a class action lawsuit in court. You may file a class action lawsuit in court, or you may be a member of a class action lawsuit even if you do not file it. This provision applies only to class action claims concerning our acts or omissions regarding the making of the direct loan or the provision by us of educational services for which the direct loan was obtained. Just as an aside, and Jeff and I were talking about this a little bit, and he may want to comment on it more, but schools essentially have an option here, right? If you currently have an agreement that includes any type of pre-dispute agreement with students that includes a class action waiver, right, you could either take it out entirely, or you could leave it in, and then you could include, assuming this rule becomes final, I should say, under the final version of the rule, if it looks like this, you would be able to leave it in but include this qualifying language. So which would you prefer to do? I mean, my take just initially is it would probably be to your benefit to include your class action language and the waiver and then include this carve-out, because in that case, if someone does bring a claim and it's not a qualifying claim, then it is not covered by the department's little carve-out here, and it would still be subject to your class action waiver. If you just take the class action waiver out of your agreement altogether, then it's no longer there. And it doesn't matter what type of claim someone brings because you no longer have a class action waiver from that person, right? So in terms of coverage, it probably makes more sense to include the waiver and then include the department's carve-out language. I guess and we were, again, Jeff and I were talking about this, the counter view on that is, does it become too complicated, right? My view is, you know, most of the agreements with class action waivers and arbitration provisions are already complicated enough. I don't think adding in the department's carve-out language will probably make it all that more complex. So mandatory class action language, any existing, so we were talking about future agreements just a minute ago. So after July 1, any new agreements that you would put into place and ask a student to sign are affected. The other thing to note is, under the proposed rule, any existing pre-dispute agreement with the student addressing a class action must be amended to include the language specifying the school will not seek to prevent a class action. So in other words, not only do you have to include the department's qualifying language in all your new agreements, the proposed rule would require you to go back and amend your existing agreements with students if they included a class action waiver to include their carve-out language. Alternatively, the department has also provided that rather than actually amending those agreements, a school may distribute a written notice to each student with which you already have one of those agreements, specifying that the school will not seek to prevent a class action. So once more, you've got an alternative, a couple options here, right? With future agreements, you could either pull your class action waiver, or you could leave it and then include the department's qualifying language. And with existing agreements you've already signed with students, you can either amend them or you can distribute to them the written notice. It would seem that distributing a written notice would be, as a practical matter, an easier route to go, but schools may have different views on that. And again, these are proposed rules. I mean, we'll have to see if all of this remains in the final version. So that was all about class action waivers. Now we're talking about pre-dispute arbitration, right? So class action waivers, you're asking someone to essentially waive their right to be a part of a class, right, or participate in a class action. Here we're asking someone to agree that if there's certain types of disputes, we and that person will go to arbitration instead of proceeding to litigation in a court. The proposed rule, or under the proposed rule, schools would be prohibited from compelling a student to enter into a pre-dispute arbitration agreement, or relying on, in other words, attempting to enforce in any way, a mandatory pre-dispute agreement to arbitrate qualifying claims. Right, so you will note in both of these cases there's an idea here that the student is being forced to sign, you know, either compelled or it is mandatory to sign the pre-dispute arbitration agreement. Presumably that leaves some wiggle room for the idea that the parties could voluntarily sign a pre-dispute agreement, although I think you'd have to be very careful about that and think a little more about what the department's getting at and whether you thought that you were in a place where that the department would not take issue. I want to note there's a definition in the proposed rule of a mandatory pre-dispute arbitration agreement, and it is defined as a pre-dispute arbitration agreement included in an enrollment agreement or other document that must be executed by the student as a condition for enrollment at the school. So we take all of this together. What it suggests to me is if after someone enrolled, and not as a condition of their enrollment, you gave them the option of signing a pre-dispute agreement and they signed it, it would not be covered by these rules because you would not be compelling the student to enter into the agreement. It would be optional, and it clearly would not have been a condition of enrollment because the student would already be enrolled. So, and again, we'll see if the final rules are still structured in a similar fashion, but it would seem that you could potentially still include some sort of option for a pre-dispute arbitration agreement, provided you were keeping in mind these parameters. Again, the department is just as they are with class action waivers. They've created a similar sort of construct here where they give schools an option of either pulling pre-arbitration provisions from enrollment agreements, mandatory pre-dispute arbitration provisions, or leaving them in and then including specific disclaimer language. So going forward, after July 1, 2017, if the final rule looks like these proposed versions, after that point, you could leave in your pre-dispute arbitration agreement in your enrollment document, right? But if you did that, you would also have to include this qualifying paragraph, which, as with the class action, essentially says, as far as qualifying claims go, you will not attempt to enforce the arbitration provision. So in other words, what you're saying is, we still got an pre-dispute arbitration clause here, but it doesn't cover any qualifying claims. It would only relate to claims that are not qualifying claims as we have defined them for this presentation. And once again, any existing mandatory pre-dispute agreement with the student would have to be amended. That's what the department is proposing. Or, once again, you could provide students who already have those agreements in place with the school a notice, essentially specifying that you would not seek to enforce that arbitration provision. Finally, as part of this proposed package, the department has included a qualifying claim notification. So schools would be required to notify and provide documentation to the feds if a matter involving a qualifying claim is filed in arbitration or in court. And part of what the department has said here is, you know, it's hard for us to keep track, particularly of the arbitrations, right? So we don't know if there are students bringing arbitrations and those are being resolved, and that's good for us to know, among other things, because it can tip us off if there's a school with a problem, right? But it is important to note that this requirement would apply if the claim is filed by or against the school. So if you have an arbitration provision, for some reason the school is filing for arbitration pursuant to that arbitration clause, the department would still require you to provide them notification, as well as with regard to litigation. And you would have to notify them within 60 days of the filing. I wanted to take just a minute to talk about the policy discussion. So what was the department, what was it that they were saying was the concern, and why did they feel like they needed to move in this direction? The department in the preamble to the proposed regs is taking the view that a class action and these pre-dispute arbitration provisions can accomplish, and they outline 4 sort of general objectives here. One is to affect whether institutions are held accountable for qualifying claims. So in other words, their concern is when these things occur and they go straight to arbitration and nobody knows about them, the public doesn't know, the department doesn't know, schools aren't held accountable. Right? They get resolved in the context of arbitration, and there's no sort of public scrutiny or pressure created by the fact that students are bringing claims and raising concerns. They make it more likely that the costs of losses from qualifying claims will be passed on to the taxpayer, which is obviously something the department would like to avoid. Reduce the incentive for institutions to engage in fair and ethical business practices rather than practices that give rise to qualifying claims. Right? So in other words, part of the department's thinking here is if you have claims that are raised in the context of class actions, or at least in public litigation, it creates pressure, not only because the department knows about it and may investigate, but there's public pressure and public scrutiny, and it can be widespread, and it can affect enrollments and all those kinds of things. And all of that pressure will promote better behavior on the part of institutions, right? Because they don't want that type of thing out in the public eye, and they don't want it to affect enrollments and all those kinds of things. And the department, as you would expect, in the preamble talks about Corinthian, and they say, there were all these arbitrations occurring, and if they had been class actions or been in public litigation, we would have known about it, the public would have known about it, other students would have known about it. It would have hurt Corinthian's bottom line, which would have made or prompted other institutions to think about those actions and perhaps take remedial action themselves. Finally, frustrate or reduce the effectiveness of ED's proposed processes for submitting and determining the validity of bar defense claims. So one of the things the department is saying is these types of class action waivers and the pre-dispute arbitration provisions make it harder for the department, or will make it harder for the department, to process bar defense claims. Right? And the real link there, by the way, is to bar defense claims that are brought on the basis that there was some sort of act or omission by the school that gave rise to a cause of action under state law. Right? So in other words, remember, going forward, after July 1, 2017, and we talked about this a couple of weeks ago, the department has proposed these new federal standards, breach of contract, misrepresentation, et cetera. But for loans that were made prior to July 1, 2017, individuals who want to assert a bar defense will still have to demonstrate that the act or omission of the school, among other things, gave rise to a cause of action under state law. The department's point here is if students aren't able to get into court in state, right, then it makes it harder for the department to determine whether or not the act or omission, in fact, would give rise to a cause of action under state law. But if students could go straight to a state court and aren't forced into arbitration, it means more of their concerns, their claims will be brought in state court. It will be clear that the act or omission of the school gives rise to a cause of action under state law, and it will make it easier for the department then to process bar defense claims because that will already be on the record. Okay. So the department claims that the risk of class action lawsuits will motivate schools to change their practices. And they cite a CFPB study that was done regarding class actions and note that the CFPB concluded that a ban on the use of mandatory pre-dispute arbitration agreements to preclude assertion of claims through class action lawsuits would benefit consumers and serve the public interest. What's interesting, and this is an important point, and maybe it will be surprising to a lot of people, the department acknowledges readily, in fact, in the preamble, that litigation may not lead to better results for individual consumers. And they even quote the CFPB and acknowledge that the CFPB in that same study that I just referenced found that it was inconclusive whether individual arbitration conducted during the study, that's the CFPB study, is superior or inferior to individual litigation in remediating consumer harm. So the point here is, you know, in the context of this conversation during the negotiated rulemaking and elsewhere, a lot of folks have been focused on the idea or laboring under the belief that the whole notion here is that the students who bring these actions will come out better if they're in litigation as opposed to being in arbitration. And the CFPB's own study has basically acknowledged that that's not necessarily the case. At best, it's inconclusive, and the department is not taking that position. So in other words, just to be clear, the department is not saying we think that the ability to get to court will necessarily make for better results for these individual students who bring these claims, right? Instead, what the department is saying, and I want to emphasize this, and this is a quote from the preamble, they say that the basis of these rules, right, relating to pre-dispute arbitration and our determination, the reason we're going in this direction, the interests at stake are not the interests of the public and consumers, but the interests of federal taxpayers. So just to bring this back full circle, what the department is really saying is we're introducing these provisions, these prohibitions on class action waivers and pre-dispute arbitration because we think, again, it will facilitate penalties sufficient to change industry behavior and shift risk away from the taxpayer, and again, permit borrowers access to state courts, which will facilitate the department's ability to establish borrower defense claims under state law. But they do not cite as one of their reasons the notion that the individual students bringing these claims will get better results. That is not the basis of these proposed rules. And with all of that having been said, I'm going to pitch it over to Jeff.
All right, well, thank you, Aaron. I mean, it's interesting to note that with the arbitration rules that the Education Department is proposing, it's really a fight over what is the better forum for handling borrower defenses. It's not as if the Education Department is saying through these rules, we're going to step in and make the determination. What the Education Department is doing is picking and choosing whether that should be done in arbitration or it should be done in courts. In theory, the Education Department should be neutral as to the outcome of a borrower defense. The borrower defense is really a battle between the school and the student. If the student prevails on the borrower defense, then the school's going to be on the hook for the direct loans that the student took out. On the other hand, if the school prevails, then the student remains on the hook. Either way, the Education Department really shouldn't have a horse in that race and should be content with whatever is decided, whether it's by an arbitration or whether in court. And from a practical standpoint, and this is what courts have blessed arbitration, and the Federal Arbitration Act blesses arbitration, there are a lot of benefits to both the schools and students that arbitration can bring. I mean, first and foremost, arbitration is almost always cheaper and faster than litigation for both parties. Typical lawsuit in courts throughout the country can take anywhere from 1 to 2 to 3 years to reach conclusion. And that's because of the congested dockets, and the courts just don't have time to get through all the cases on their dockets. In arbitration, you can get to resolution very quickly depending on how fast the parties want to go and how fast the arbitrator wants to go. You can have cases resolved in a matter of months. An arbitration that goes a year is it's pretty much unheard of. So in arbitration, you're going to get stuff done faster. You're going to get the borrower defense resolved faster, which would seem to be in the benefit of the Department of Education to get borrower defenses done more quickly. Arbitration is also typically a lot cheaper than litigation just because it's a lot less formal. You have simpler procedural and evidentiary rules. If you have a dispute in arbitration, you don't need to file a bunch of motions, have your attorney show up in court and fight and argue about it. Instead, you typically just file a letter or something with the arbitrator, get the arbitrator on the phone, the arbitrator talks it over with the parties and resolves the issue. You get to your hearing, and things are done much more flexibly in arbitration as to the discovery and the hearing. In arbitration, you're going to have a hearing typically in a conference room and maybe at a law firm, at a hotel. And it's just a lot more flexible in scheduling because you're dealing with one person, an arbitrator who doesn't have other cases going on. He can give his entire attention to the case at hand, whereas in court, you're just one of hundreds of cases that are on the docket. Another good thing about arbitration, and this has come under attack, but I think schools and students both benefit from this, is the fact that in arbitration, you can keep your disputes confidential and put in your arbitration agreement that no side will talk about it or disclose it to other sides. The arbitration award will remain confidential. That in itself helps to affect the resolution of the case. The confidentiality has come under attack because some, especially states' attorneys general, have said, well, that favors schools and allows them to do wrong, and nobody ever finds out what they're doing wrong because the students can't share that. Well, that's not really true, because even under a confidentiality agreement, the students can still testify and talk to government officials about what they claim happened to them. But keeping the arbitration process confidential often is a big benefit to the students as well, because a lot of times the schools in defending cases brought by students are going to raise what the students did or did not do, their circumstances, why the students failed in school. There might be personal issues, and students do have an interest in keeping that confidential. Now, another benefit of arbitration, which I mean obviously just benefits more to schools, is that they can avoid class actions and thereby limit their risk. The waiver and the ban on class actions in arbitration has been blessed and approved by the United States Supreme Court, and schools can take advantage of that to avoid class actions. Overall, arbitration is shown to achieve fair outcomes. I've been involved in many student arbitrations. Arbitrators, I believe, are fair. They try to do the right thing. They're not biased or predisposed to rule for schools. They're not predisposed to rule for the students. They take their job seriously, and I think overall they try to achieve a fair outcome, and they do it in a lot faster and more economical manner. Now let's talk now about the points of significant concern with the Education Department's regulations on the use of arbitration in enrollment agreements and other documents. I think first and foremost, I think the Education Department has even signaled this, is that there's really a question on whether the Department of Education has any authority to ban schools from using or enforcing pre-dispute arbitration agreements with students. Think about this. We've had the Federal Arbitration Act in effect since the 1920s, almost 100 years now. And that act says that pre-dispute arbitration agreements are generally valid and enforceable. And it implements a strong federal policy favoring arbitration of disputes. And courts love arbitration. The reason they do so is because their dockets are already overcrowded. And if they can have parties agree to arbitration, courts are more than happy to have parties go and arbitrate their disputes and leave the courts alone. The Education Department conceded that it does not have the authority to displace or diminish the effect of the Federal Arbitration Act. But yet, in these proposed regulations, the Department is claiming that it can bar pre-dispute arbitration agreements that would clearly be enforceable under the Federal Arbitration Act. Now, it's clear the Education Department has no express authority from Congress to regulate arbitration agreements. There's been no such claim by the Department. And if you read through the Higher Education Act, there's nothing in there that talks anything about arbitration. And a good point of reference and comparison is to look at the Dodd-Frank Act, which was enacted 6 years ago in 2010. The Dodd-Frank Act gives authority to the Consumer Financial Protection Board to regulate arbitration agreements and consumer financial agreements. And in fact, the Consumer Financial Protection Board has its own proposed rule pending that would ban class action waivers in consumer financial agreements. So compare that to what the Higher Education Act has done. With the Dodd-Frank Act, Congress has said, CFPB, you may investigate and you may regulate arbitration. There's nothing in the Higher Education Act that's anything like that we find in the Dodd-Frank Act. So instead of express authority, the Department of Education is asserting that it has implicit authority. And this is under Section 1087D-A6, and we've talked about this earlier, the provision. It says that the provision has to be necessary to protect the interest of the United States and to promote the purposes of this part, the Title IV program. And the question is, does a ban on pre-dispute arbitration agreements or class action waivers, is that really necessary to protect the interest of the United States? And another point, too, is that this implicit authority, in putting aside the issue of whether it's necessary to protect the interest, any authority that's implicit that the Department of Education has under any of its statutes, it's limited, it's circumscribed by other federal statutes, including the Federal Arbitration Act. The Department of Education cannot issue rules that violate federal statutes. I mean, for example, federal law has long prohibited discrimination on the basis of race, national origin, sex, and other factors. The Department of Education could not, under its implicit authority under Section 1087, come in and say, well, notwithstanding those federal prohibitions on discrimination, we're going to issue rules that effectively allow that. By the same token, these other statutes, such as the Federal Arbitration Act, apply and restrict what the Department of Education can do. And so the implicit authority is to do stuff that's necessary to protect the interests of the United States, but by definition, the interests of the United States are defined by other federal statutes, such as the Federal Arbitration Act. So if you have provisions in program participation agreements that conflict with federal statutes, such as the Federal Arbitration Act, presumably those provisions are not necessary to protect the interests of the United States. So in going through this, it seems like the ban on pre-dispute arbitration agreements would violate the Federal Arbitration Act and should not be allowed. Now, this is a hot issue pending with the National Labor Relations Board. And it's kind of a similar issue, not the exact same issue, but it's a similar issue. The NLRB has been deciding that employers can't have arbitration agreements with their employees that ban class action claims in arbitration. And there's been a split on this. For the past several years, the Fifth Circuit has struck down these decisions by the NLRB. And the reason they've done that, they said, look, the National Labor Relations Act is silent about arbitration, doesn't say anything. And because of that, we're going to apply the Federal Arbitration Act. And you, the NLRB, can't ignore the Federal Arbitration Act just because you think the Federal Arbitration Act is not a good thing in employer-employee relations. Now, recently, and you may have seen this in the news, other courts, namely in the 7th and 9th Circuits, have come up with a different conclusion, and they have allowed the NLRB to tell employers that they cannot enforce class action waivers in their agreements with their employees. But the reason is not so much antagonism towards arbitration. It's just there's a provision in the NLRA that prohibits employers from interfering with collective action by employees. And these courts have been very careful to point out that the fact that you can't prohibit collective action doesn't mean you can't compel arbitration. It just means that if you are going to compel arbitration, you would have to allow class action claims to be asserted in the arbitration, which for many employers is very undesirable. They'd almost rather be in court if they're going to be subject to class action claims than to be in arbitration. Now, the Department of Education contends that students need to be able to present borrower defense claims, quote, to an authority well situated to consider the merits of their claims and provide effective recourse directly against the school, end quote. That's their justification for why they think that arbitration is bad and students should be entitled to present their borrower defense claims to a court. The problem with this contention is that for many years now, decades, both Congress and the United States Supreme Court have made it clear arbitration is just as effective and just as good as litigation to determine the validity of most all legal claims. There are virtually no exceptions to this. Statutory claims can be subject to arbitration, common law claims subject to arbitration. And there's really no apparent reason that we see why there should be any exception for borrower defense claims. I mean, a borrower defense claim typically involves alleged misrepresentation or some statutory violation, maybe of a Consumer Protection Act, saying the school either made a misrepresentation or omitted some fact or maybe it breached its contract with the student. Those claims, garden variety common law claims or statutory claims, that arbitrators handle all the time. And so Congress and the U.S. Supreme Court has said, arbitrators, you are just as good as we are in deciding these claims. And so there's really no reason that the Department of Education should be favoring litigation over arbitration in that regard. So now let's transition. In the meantime, while the proposed rules are still out there, what can you do with your arbitration agreements to make them better and to stand up better in court? If you have a class action waiver or a pre-dispute arbitration agreement, you obviously should continue to monitor the rulemaking closely. It's important you do so because the rule becomes final, and if you're doing stuff to violate your program participation agreement requirements by having prohibited arbitration agreements. I mean, you could face sanctions with the Department of Education and problems in the future. So in the meantime, let's look at what you can do, though, with your arbitration agreements and the language in that. And handling cases and student claims in the past several years, a lot of times the students will try to resist arbitration, and they'll file a lawsuit, in which case the school has to file a motion asking the court to force the student to go to arbitration. And inevitably, a lot of students will try to raise defenses and say, no, I shouldn't have to go to arbitration. I'm entitled to stay in court. And the first and foremost thing is that with any arbitration agreement, you've got to make sure that you have the student's assent to it, his agreement. Now, it may sound fundamental that, well, I can't enforce an agreement against a student who hasn't agreed to it. You can get into evidentiary fights about whether the student actually signed the agreement. Some schools have gone to, and understandably, have gone to electronic signatures on the documents. It's easy and quicker to pull up documents on a computer screen, have the student sign a little box saying, yes, I agree to it, and I'm electronically signing this. That can cause problems, because then inevitably, it's a lot easier for a student to deny signing something electronically where all they did was check a box on a computer screen than if their wedding signature was on the document. So what I'm trying to suggest here is that, if possible, schools are better served if they can avoid disputes about whether a student agreed to arbitration by getting a wedding signature on some document, either the enrollment agreement or some other document that says, yes, I have completed an enrollment agreement, yes, I acknowledge that there is an arbitration agreement in there. Another issue that sometimes arises in fights over whether a student should have to arbitrate is whether your arbitration agreement is mutual, meaning that both the school and the student must arbitrate any claims between them. Where school could get in trouble is if the school tries to reserve a right to itself to sue a student in court over any kind of claims. Maybe school wants to sue the student if the student still owes the school money, because they think, well, it'll be faster if I can just get into court, get a quick judgment, and go and collect. And that's a lot faster for me, the school, than if I have to go into arbitration. Problem with doing that is a lot of courts really disfavor that and say, wait a minute, no, that's not fair. If you're going to require the student to arbitrate his claims against you, the school have to arbitrate any claims you have against the student. So it's very important that in your arbitration agreement that you have mutuality in there. And then another point, too, is to be careful in the drafting of the arbitration agreement, and especially if it's an enrollment agreement, is that there's no argument that you, the school, have the right to retain, a unilateral right to change the arbitration agreement. I've seen this argument from several students in cases where they try to resist arbitration, and they say, well, yes, there's an arbitration agreement in here, but the language of this enrollment agreement allows the school to change it at will and do whatever it wants. And the issue usually pops up is that you've got a clear arbitration agreement in the enrollment agreement, but then the enrollment agreement incorporates other documents, such as a school catalog, that may change from time to time. And so the fact that the school catalog may change, then the student comes in and says, well, if you can change the school catalog, which is incorporated into your enrollment agreement, that allows you to change the arbitration agreement. Now, there's easy ways to get around that, and the best way is just to make sure that the arbitration agreement is ironclad, and there's provisions in the enrollment agreement that suggest or clearly state that no matter what happens with any school catalog or other incorporated documents, none of that can possibly change the arbitration agreement. And then another point in arbitration agreements and best practices is just in terms of the expenses of arbitration and arbitration filing fees and arbitrator compensation. The courts are more likely to enforce your arbitration agreement if the students are not required to pay significant expenses to arbitrate. For example, if you have arbitration subject to American Arbitration Association rules, which is the predominant provider of arbitration services in the United States, as of now, if a student files a claim, the student has to pay $200 and the school has to pay $1,700 with each filing. Now, beyond that, that's already set in stone, but beyond that, it's really up to the parties as to how you're going to pay for the arbitrator, which can be a significant expense. The more that the school is willing to bear the cost of the arbitrator, the more likely the court will be to enforce your arbitration agreement. And then a point that's not on our slides here, but it came to mind, is that in terms, when you're drafting the arbitration agreement, make sure it has a broad scope in it. Because if there's any, the obligation to arbitrate is determined by the agreement itself. And so you want your agreement to be broad and say it covers any type of claim by the student, whether it's a common law claim, a statutory claim, any way related to either the enrollment agreement or the student's enrollment at the school. That way there's no out for the student to come in and say, wait a minute, my dispute with the school really has nothing to do with this enrollment agreement, and therefore I'm not required to arbitrate. So make sure your arbitration provision is very broad. And then lastly, and I assume that if you're having an arbitration agreement, this is probably a no-brainer, but make sure that you have in there that you're clearly prohibiting any type of class action or consolidated claims in arbitration. You want to spell that out in the agreement so that there's no way the student can come in and say, okay, even if I have to arbitrate, I'm entitled to do a class action arbitration, because that's the one thing you definitely want to avoid. And lastly, I'll turn it back over to Aaron. We've got some resources to talk about.
Thanks, Jeff. So as always, we've got here at the end, I mean, obviously this webinar series is a resource, and I'll mention again, I think I've mentioned before, that in addition to doing this series on the proposed rules, we're going to do a series after the final rules come out. And I'm not sure how many pieces that'll be in. It'll depend on the complexity of the final rules, but we'll be digging into those in a fair amount of detail and walking through them with the hope that anyone who attends that series will have a very strong sense when they come away from it as to what the new rules require. And we do expect that new rules will make it. I don't know exactly what they'll look like, obviously, but we would be very surprised if you did not see a final rule package hit the wire, you know, October 30, 31, or November 1st. Also, we have our blog, REGUcation. We're pretty busy right now putting the webinars together, but we do expect to be writing some more about these proposed rules and other topics in the future, and are always happy for you to check out and keep an eye on the blog. So that's our contact information. This is a complicated and difficult subject to think through, and it's a lot to sort of let wash over you. And of course, there are also some schools that may not include arbitration or class action waiver provisions in any agreement that they have, and so you may not have as many questions. I say all that because we only have one question today. And the question is, does the class action language also apply to prom note agreements used for students receiving institutional loans? Let me just start by saying my expectation is that that type of instrument would clearly be covered by the proposed rule pending by the CFPB. Jeff, would you agree with that?
Yeah, I would agree that aside from whether the Department of Education's rule would apply, the CFPB's rule would apply, because this would be an extension of credit by the school to the student. So in that case, assuming the CFPB's rule goes forward and becomes final, and it is going to be subject to challenge, there's the financial services industry is geared up for a challenge to it. But assuming that rule became final, that would apply to promissory note agreements. But beyond that, even the Education Department's rule, I mean, directly it doesn't seem like it would apply, just because this does not involve a federal student loan. However, typical claims are going to, if a student were to bring a claim, typically it probably wouldn't be just on the promissory note that the school has issued. It's probably also going to affect the student's direct loan from the federal government. So in a way, it's going to be all tied up into it anyway. And so typically, if they're going to have a dispute over the promissory note, the loan that the school has issued to the student, chances are, if the student's also gotten federal student loans, the whole dispute's probably going to end up in court, assuming that the ED's rules go forward, are final, and are found to be valid.
Yeah, and we talked about earlier, I think there's enough wiggle room in a couple of these provisions that the department could, if it wanted to, take the position that, well, first of all, let me just back up and say, too, sometimes folks will actually incorporate institutional financing instruments into the terms of an enrollment agreement. So you'll say something in your enrollment agreement like this agreement, along with, the prom note or whatever you're signing for institutional loan, represent the whole agreement between, if you've got something like that, someone could take the view that the terms of the prom note are actually part of the enrollment agreement and were, as a consequence, part of a pre-dispute, arbitration arrangement. But then also under the class action rules the department has proposed, I mentioned earlier, I mean, they're, in a couple of places they're written in a way that don't seem to me to be specifically tied to an enrollment agreement, but ostensibly could extend to any pre-dispute arrangement or agreement, whether that be in the context of an enrollment agreement or elsewhere, between the student that relates to a qualifying claim. And remember, a qualifying claim is one that involves either or relates to a direct loan or the educational services for which that direct loan was provided. So someone could ostensibly try to bring some sort of claim that would relate to educational services and overlap somehow with the prom note or the prom note agreement. This is all just to say I would certainly expect that either via the CFPB or the department, one of those agencies would make take the view that that type of provision would be covered. Or at least let me say I think it's certainly a possibility, you know, and we'll leave it there, and we'll see what the final rule looks like from the department. Keep a lookout for the webinar series on the final rules that we hope to be doing in November, December, after we expect the final rule will have been published. Thank you much, and everyone have a safe and productive week. Bye.